case, but in the court of public opinion, we're the winners. And I want to mention something. You know, most of us, you know, when we vote, we realize we're minority voters in one way or another. We vote for all these candidates that don't win quite a bit of the time, and we vote for causes that seem to be lost causes, but we're the majority. When it comes to medical marijuana, we are the majority. Anybody who's opposed to it, they're in the minority. It's a very unusual position to be in, at least for me, and for most of us, I think. But we have to realize that we're not trying to convince people that medical marijuana is efficacious or that it works or that it should be legal. We're just trying to convince a few politicians of it who are being wagged by the tail, and I'll get into that. Actually, 8 of the jurors repudiated the verdict, two of the alternates. This had never happened before in American history. Now, I noticed that it's heating up because the jury in the Oakland case, 6 members of the jury in the Oakland case complained I'm talking about the Riders case, have just complained about what happened in their jury. So 4 days after the jury convicted me, they were back in the courtroom in the audience section for the judge to look at while he was deciding whether I was going to be remanded into custody immediately. Now, I know that most of you were very relieved that I was given only a 1-day sentence 6 months later, but I was more ambivalent about it. Because, well, you know, it's pretty good getting a 1-day sentence, and actually the government owes me 12 hours because I served 36 hours. But let's say they had given me 5 years and remanded me to prison right then and there. You know, it would have been a lot more headlines. I would have had a book sold by now on this. And I think it would have moved the laws. And I think that the government and the judge realized that if he had done that, that it would have caused quite a bit more, I'm going to just use the word controversy. Right now, the government is appealing my sentence. And they want me to do the 21 months or 5 years or whatever. And I'm appealing the conviction both on technical and on constitutional grounds. And I wanted to go through them because they're of importance. And the first is that the judge, in pretrial, the judge was looking at the search warrant, and he realized that the DEA agent, Pickett, had lied on the search warrant. So instead of allowing a withering cross-examination, he said, well, I'm just going to excise certain parts of the search warrant. And what was left after he excised everything was that I had a high electric bill. And then my attorney said, well, let's compare it with other electric bills in the area. And the judge said, I'm not going to allow it because there are industrial users in the area, and then the search warrant might not be good. So we're appealing on that basis. Then we're appealing because the judge found that the prosecutor had actually lied to the grand jury. And the judge found that he had misled the grand jury. But the judge said that no harm was done. And I don't know, if we had lied, if one of you had lied to the grand jury, you would be up for perjury. And here the prosecutor is lying to the grand jury. And he shouldn't have even been testifying. So those are the 2 technical grounds that we're appealing on. And we may very well win on those grounds. If we win, for instance, on the first one, it would mean that the way that search warrants are looked at would change. It would change, it would have court precedent there. But there are other more important issues that we're covering. And I'm going to go through these very quickly. The first is the 9th Amendment. Now, you know, the 9th Amendment has never been used in court work, or or it's been used very little. Even the Griswold decision, which was for birth control, and the abortion decisions did not rely on the Ninth Amendment. And what the Ninth Amendment says is that those rights of the people that are not enumerated in the Constitution remain with the people and shall not be denigrated. That means, like, for instance, you have the right to eat strawberries. There's nothing in the Constitution that says that you have an inherent right to eat strawberries, but you have it because it's been there. Those are some of your natural rights. And there are two natural rights that the Ninth Amendment covers in this case. And the first is that you have a right to seek health. Everybody has a right to seek health in their own way, whether you want to use herbal supplements, or whether you want to use vitamins, or whether you want to use religion and prayer for your health. You have a right to determine how you will gain your health. And so by restricting medical marijuana, the government is restricting your right to health. And then the second part is this. Before the Constitution, people in the United States had the right to use marijuana. And then, up until 1937, there were no federal laws against marijuana. So that was 150 years that people were using, approximately 150 years during the United States that people were using marijuana. Then in 1937, the government realized that in order to restrict marijuana, it would have to pass a constitutional amendment. So instead, they passed a tax law that was confiscatory. It was a $100 an ounce tax, which in 1937 was a lot, since an ounce only cost a couple of dollars. So people would be arrested not for possessing marijuana, but for not possessing the tax stamp or paying the taxes on the substance. And it wasn't until 1968 that marijuana was made illegal. I believe that that's unconstitutional. People had the right to use marijuana through that entire period of time, and it was only in 1968 that it was made illegal. Well, if people had the right to use it, then that was a constitutional right. How can that be denied? And this, you know, years ago, I wrote a paper that said that the Ninth Amendment is probably going to be the amendment of the 21st century, and I hope this is the first case on it. Then the 10th Amendment, that's our states' rights amendment, that any rights not given to the federal government remain with the states. And the state has two basic rights, one in this area. One is to regulate the health of its citizens, and the other is to regulate doctors. So the federal government is violating these rights in terms of the 10th Amendment. And where this comes in, especially in my particular case, is in the Constitution, and these are interwoven, but in the Commerce Clause of the Constitution that regulates interstate commerce. Well, look, this marijuana was grown in California by Californians, for Californians. It was recommended by California doctors for people to use in California. I fail to see where there's any interstate commerce. So if there's no interstate commerce and the state has the right to regulate health, and it's already determined that marijuana is good medicine, then why is the federal government in here at all? And then another issue is 885D. And 885D says that it's a federal law, and it's part of the Controlled Substances Act, and it says that if you're a federal, state, or city health or safety officer, and you're in the course of your business, you're dealing with controlled substances, you're immune from prosecution. Well, that's so that narcs can buy and sell pot and other drugs and not get arrested for it. And I was a health and safety officer that the city of Oakland had appointed, and I was told by the city attorney's office that I was immune from prosecution under this law. So that, Judge Breyer said that a literal reading of this would seem to immunize Rosenthal from prosecution. But then he said, I'm not going to allow that, and then he didn't allow the jury to hear it. And then there's the other thing. Let's say the city attorney was wrong. Let's say the city attorney's office was totally wrong, and they had told me that I was immune from prosecution, but I wasn't. well, then I should have been immune from prosecution because of estoppel, which means that if you're told that something that you're doing is okay by the federal government, they can't then come in and say, look, it isn't right, you're breaking the law and you're under arrest. And that's the idea of estoppel. So needless to say, I was a little surprised when I was arrested. And as you